Welcome back, my dear students. How are you? How is everybody? And today we are going to talk about a new chapter in human resource management. And today we're going to talk about knowing your rights and responsibilities. An employee, like we said before, the basics are employer is the owner of the job or the boss. Employer. Employee is the one who's working for the employer. Okay, the one who's working for the employer. So what are the employees rights and responsibilities? What is the employer rights and responsibilities? That's what we will talk about just now. So let us first share the screen, then yeah, we'll share the screen first, then we'll go to see how about what we're talking about today. The subject was so knowing your rights and responsibilities. So you have your own rights and there are obligations on you. Responsibilities is kind of obligations, like things you ought to do and things you ought not to do. What are the duties you should do? What are the things which you have to avoid? Otherwise, you it will be counted on you if you made a mistake or make a serious fault. So let us see what we are going to study here. The learning outcomes of this chapter describe statutory rights, contractual rights, contractual rights, what you have to take from this job, due process, what you have to give to this job, and the legal implication of those rights, and even the consequences, all the legal consequences regarding to the job. Identify the job expectancy rights. What are you expecting from this job for employees? Okay, of course, our expectancies for any job is like we are always expecting the best benefit we have to maximize our benefits, to maximize our benefits. That's what we are looking from the job, to increase our morale, to increase our spirit to work, to increase our production, to make all the things possible for us to increase working. Explain the process of establishing disciplinary practices, including the proper implementation of organizational rules. That's also another point. The learning outcomes also continued. Discuss the meaning of discipline. What do you mean by the word discipline? And how to investigate disciplinary problem. Discipline, putting everything in order. Putting everything in order. Outline the differences between progressive and positive disciplines. Okay. Identify the different types of alternative dispute resolutions or the dispute. There might be troubles in any organization, and there might be negotiations, and there might be fights, and there might be conflicts between the management and between the workers. So, how we will go to solve any dispute, any contradiction in the points of view, any contradiction in the ideas, all this in this process. Employees' rights. Let's see now what is we said employee again, employer, 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 employer is the owner or the boss of the job. But employee is the worker who's working for another person, who is the subordinates, the clerks, the people who are working in any organization. Okay. Expectation of fair treatment. That's what we said before, the equality, a fair treatment from employer. Employees' rights. So, what is your rights as an employee? What are your rights as employee? Guarantee of fair treatment, a good treatment. Okay, all the people are the same. All the people are equal. So, this is what we call a fair treatment of employees, particularly regarding an employee's rights of privacy. So even the rights of your privacy as well, the same thing. Employees must exercise reasonable care. They must exercise reasonable care. That's fine. Three, employers can be held negligent by outside parties or employees if reasonable. So employers can be held negligent by outside parties or employees if reasonable care is not exercised. So if you as employer did not care about the people who are working with you, of course they will neglect you. If you don't give them the rights, if you didn't Listen to what they want to say. If you didn't make them participate with you in decision making, in making decisions, then what is the use? There will be a kind of stiff relationship between the manager and the management from one side, and between the employees from the other side. So you want to get the dispute to the lowest level. You don't want dispute to happen in your organization. That's the point. Okay. Employment protection rights. Statutory rights, rights that derive from legislations. This is derived from legislations. Okay. Contractual rights. When you write a contract, you have rights. The right to take your pay, if there are, like we said, direct and indirect benefits, like we said in the previous lecture. Uh, Things like, what will happen if I get sick? What will happen if I want to take a sick leave? What will happen if I want to take a travel vacation? Like I want to go home, back home for 10 days or 15 days. Do you guys pay me vacation pay or no? What about the health insurance? Are you trying to cover me? Okay, how far? How many percent? 60% of coverage or 80%? Are you covering everything, including the cosmetics, the dentures, all this? Or there are types of things that are not covered in the contract or in the health coverage of the contract? So due process, right to be heard also, especially during disciplinary process. Employment rights not a guarantee. See this? Employment rights not a guarantee means there might be, and otherwise, why you see always the people are complaining in the Ministry of Labor? Why do the people complain? Because some of the employers don't give the people the rights. That's why they go and fight for it. Employment protection rights. We said this question. We will watch this video now. Then we will answer about these questions. What do we mean by employee rights? Okay, you want to work in a company and you need to know all your rights. And we'll check out about the Canadian rights, the Canadian Charter of Rights. What is it? What is guaranteed in any job contract you have? You sign a contract. What can you guarantee in it? Okay, and what are the cases, and why should you go and complain? What are the reasons for you to complain if you didn't have all your rights? Okay. How are the employee rights applied in Canadian business organizations? And this is very important questions for your quizzes. Please notice, I put it in red. So please make sure that it is very important in all your quiz, because we want the application side. We are studying the academic not for the sake of the academic studies, but the application of the academic in a real life situation. This is what we care about. So how far you get use of what you learn here in these classes regarding the Canadian society. Come, let's go and see this video first. Then we'll come back and complete what we are working on right away. Okay, okay, dokie. Let's see. You can see a lot of videos, but I'm just selecting the videos which is very shortcuts, like it takes few minutes and it gives the
HR
conclusion.
Basics is
You
a
can
series
watch
of
other
short
videos if
courses
you
designed
want.
to highlight what you need to know about a particular human resource management topic. In today's HR Basics, we explore employee rights affecting the employment relationship and the appropriate management of those rights. Employee rights are the powers and privileges derived from the law and tradition within the context of the employment relationship. Employees have some basic rights as citizens, but those rights are influenced by human resource policies and rules that an employer establishes. However, there are now a multitude of laws and employee rights that affect the employer-employee relationship. Rights are offset by responsibilities, which are obligations to perform certain tasks and duties. Employment is a reciprocal relationship in that both the employer and the employee have rights and obligations. The reciprocal nature of rights and responsibilities suggests that each party in the employment relationship should ideally regard the other as having rights and should treat others' rights with respect.
See this? So I'm
Human resource
expecting, I'm expecting to have the respect from the others and from the employer, my employer, to respect me as well. And uh, the environment of work should be a friendly environment. I'm expecting that I will work in a place where all the people like each other. It's not a warrior. It's not a kind of a warrior place. It's not a war area. It's an area for the people who are working together. So they must be all working in a pleasant and in a very good, like, organizational climate. Like, it's, we call it organizational climate, which means that everything in the organization is encourageable to increase your production. People love each other, no conflict, no fights. People are very good with each other. Everyone is understanding the other. I have the right to understand what you are saying, and you have the right to understand what I'm saying. Everything must be clear. Okay, I take my pay, I take my rights. I'm health totally covered by insurance. This and that, all these points together will make us. So this all will protect you as an individual. It will all protect you when you go to work in some place. Let's complete the video.
Professionals must help create a work environment that honors fairness, protects individual privacy, treats all workers with dignity and respect, while at the same time allowing the business to succeed. Employers have an obligation to recognize and respect the rights of employees through appropriate management practices. Employee rights are the powers and privileges within the employment relationship, while rights management is about the planning, organizing, leading, and controlling of these rights. Let's first explore employee rights as the powers and privileges within the employment relationship. At the core of the employment relationship are 6 concepts related to employee rights.
See, those are the employee rights: one, two, three, four, five, six. Contractual, employment, just cause, due process, organizational justice, dispute resolution.
They include contractual rights, employment at will, just cause, due process, organizational justice, and alternative dispute resolution. When individuals become employees, they take on both employment rights and responsibilities. Those obligations can be spelled out formally in a written employment contract. Contracts formalize the employment relationship. An employee's contractual rights are based on the specific contract with the employer. Traditionally, executives and senior managers have negotiated individual employment contracts, but they are now becoming more common for highly specialized professional and technical employees who have scarce skills. As we've discussed, an employment contract is a formal agreement that outlines the details of employment. This employment agreement should address all particulars of the employment relationship, including base pay and incentive compensation, basic and supplementary benefits and prerequisites, key job functions and performance criteria, contract term, and terms and conditions for terminating employment.
You see, all these are
Employment
the
at will is a
contract
common
elements.
law doctrine stating that employers have the right to hire, fire, demote, or promote whomever they choose unless there's a law or contract to the contrary, and employees can quit at any time with or without notice. There are certain exceptions to this employment at will doctrine. First, the public policy exception, where employees can sue if fired for a reason that violates public policy. Second, the implied contract exception, where long service, promises of continued employment, and a lack of criticism of job performance might imply continuing employment. And finally, the good faith and fair dealing exception, which is a covenant of reasonable behavior that exists between employers and at will employees.
So one thing I want to say here: don't expect, and this is in the employee expectations. Don't expect that you will do something like uh, misconducting, misbehaving while you are working, and you will accept that they will keep you still working in the organization. No, in the company. No, no. What's expected what's expected from you is that you do your best, okay? But if the opposite happened, in that case, you are not welcomed in this organization anymore. For that reason, in the Canadian law here, there is a period of time, it's called probation period. So almost most of the companies like 3 month, 3 month, around 3 month. Within these 3 months, uh, people usually they are under like we can say under the microscope, and they are very focused. They are focused on them so much. If they find they do mistakes, intent by they mean it, they are doing they know they are doing wrong things in the job, and still they are persisting and insisting to do it. In that case, they will be fired in the probation period. So you cannot complain. Like when you go, the Minister of Labor will tell you, sorry, have been in the probation period, and we cannot do to you anything. We cannot give you a hand because it's the right of the employer in this time within the 3 months. If you discover or find out that you are not working as the standards say and as the job description and the job analysis and the job contents of your duties. You don't do your duties as it's supposed to be with a duty of care, with responsibility, whatever. He can fire you in any time within these 3 months. Again, it's
Employers
called the
that run
probation
afoul of
period.
employment at will restrictions may be guilty of wrongful discharge, which involves the termination of an individual's employment for reasons that are illegal or improper. Employers can take special
See,
precautions to reduce wrongful discharge
illegal or
liabilities.
improper.
Having a well written employee handbook, training managers, and maintaining adequate documentation are keys to prevent wrongful discharge. Closely related to wrongful discharge is constructive discharge, which is the process of deliberately making conditions intolerable to get an employee to quit. Under normal circumstances, an employee who resigns rather than being dismissed cannot later collect damages for violation of legal rights. Just cause is a reasonable justification for taking an employment-related action. Union contracts typically require that the employer provide a good reason for disciplinary actions such as dismissal, but this protection does not necessarily extend to at-will situations. Even though the definitions of just cause may vary, the overall concern is fairness. To be viewed by others as just, any disciplinary action or employment-related decision must be based on facts in the individual case.
See, must be based on facts.
Due process, like just cause, is about fairness. Due process protects employees from unjust or arbitrary discipline or termination. Due
See,
process
the due process, it protects you as an employee. It protects you just from if the employer does not want to make you work anymore for him, is not welcoming you, and without any reasons, in that case you can go on the due process because you say I didn't do anything wrong and didn't do mistakes, and even though he's firing me, why? From unjust or arbitrary discipline or termination.
occurs when the employer is determining if there's been employee wrongdoing or uses a fair process to give an employee a chance to explain and defend his or her actions. Due process typically involves thoroughly investigating all employment actions and giving individuals the opportunity to express their concerns to objective reviewers of the.
So the law give me in the due process the chance to defend myself as an employee and to say all I have to say, because justifications may find out that the employee was right, right? And that the employer should not let him out or fire him. Okay? So still you have a chance not to be fired without just a word of a mouth from the employer. No, it's not so loose like this.
The facts based on a situation. Due process represents ethical and respectful treatment of employees, and organizations that fail to utilize such processes risk being seen as unethical. Organizational justice is a key part of due process. And that organizational justice is about the fairness of decisions and resource allocations in the organization. Employees' perceptions of fairness and justice in the workplace influence their attitudes, behaviors, and overall engagement.
Okay, let's understand what the meaning of this sentence. Employees' perceptions of the fairness and justice in the workplace influence their attitudes and behaviors. Of course, my perception of the fairness, this is a fair company which is treating all the people with equality. All are having the equity. All are sharing like each other. No one is better than other one. All are the same. Okay, that's fine. Then this will influence my attitudes. Yes, it makes me own. I will own, in this case, as an employee, I will own positive attitudes. I will own positive attitudes. Because of what? Because I already have a basic ground that this is a good company. For that reason, I will feel fine. I will feel with a high morale and high appetite to work, and my productivity will go higher and higher and higher. And also, it will reflect on my own personal behavior with the other people. I will treat them in pleasant, in a good kind, in a kind way, right? Okay.
Individual perceptions of fairness or justice in the workplace depend on at least three different types of assessments: the process of decision making, the actual decisions made, and how the decisions are explained to employees. Procedural justice is the perceived fairness of the process used to make decisions about employees.
Okay.
Distributive justice.
Okay. The decisions are well. There is fair decisions about the employees. That's fine. All are treated the same. That's fine. All we have bonus of $300,000 in the company. Profits. Okay. Is it divided or shared in equal ways between the people, or some people take and some people no? Some people take money from the profits and some people no. So here, that's what is it. The second one is disruptive
Which is
justice.
perceived fairness in the distribution of outcomes, and
That's what I'm talking about. The fairness. The fairness decision is like for all the people. Vacation pay is 4% for all the people. So vacation pay is 4% for all the people. It's not 4% for some people and 2% for others. No, it's for all the people 4%. Okay. The money which comes, the outcomes, or the profits of any organization divided equally between the people who are working, the employees, or no? If it is divided equally, then there is equity, then there is a good decision making. In that case, the attitudes of your employee will be higher and higher and will be positive.
personal justice, which is the extent to which a person affected by an employment decision feels treated fairly, with dignity and respect.
See, this is personal. Personal always comes to the respect issues. And so, whenever you feel you are treated with respect in the company you are working in, this will increase your morale, raise your morale. It will make you feel that you will have a positive attitude, and it will increase consequently your productivity.
Disputes between management and employees about work issues are normal and inevitable, but how the parties resolve their disputes is also important. Alternative dispute resolution, or ADR, is the procedure for settling disputes without litigation. High litigation costs, delays in the court system, and damage to the employer employee relationship have prompted growth in alternative dispute resolution methods such as arbitration, peer review panels, ombudsman, and mediation.
See, all these are ways to to fix any kind of conflict result from unfair treatment or other mistakes done by the organization or the decision maker in any company. When I'm talking about the organization, it means a company, but the broader term is organization because it includes all kinds of organizations like companies, like profits or non-profits. Okay, so this is the word organization is a broader term. So we use it instead of the word company.
Disagreements between employers and employees can result in lawsuits that are costly and time consuming. Consequently, to settle disputes, some organizations use a process called arbitration. Arbitration is a process that uses a neutral third party to make a binding decision, thereby eliminating the need to involve the courts. Arbitration has been a
So I'm doing the arbitration inside any company because I don't want to escalate the problem to go up to courts. I want to end the problem. For that reason, I'm just trying to solve out and to fix out all the problems. What are the problems, reasons, and to solve it within the parties that are touch, touched by the problem. I want to see these people, collect them together and find a solution. But I don't want to escalate the situation to go furthermore into the courts. I don't want this to happen.
common feature in union contracts. However, it must be set up carefully if employers want to use it in union free situations.
Mm.
Some organizations allow their employees to appeal disciplinary action to an internal committee of employees. This panel reviews the actions and makes recommendations or decisions. Peer review panels use fellow employees and perhaps a few managers to resolve employment disputes. Panel
See,
members are specific.
like we sit together as employees and sometimes with few managers, with some managers, and try to solve out. It's a kind of like, it looks like arbitration, the same thing. But this is very limited, not like the arbitrations. The arbitration is broader, but the peer review panels is limited in this situation.
Specifically trained volunteers who sign confidentiality agreements after the organization assigns them to hear appeals. Still, other organizations ensure process fairness through ombudsmen, individuals outside the normal chain of command who act as an independent problem solver for both management and employees. At many large and medium sized organizations, ombudsmen have effectively addressed complaints about unfair treatment, employee supervisor conflicts, and other workplace behavior issues. Ombudsmen address employees' complaints and operate with a high degree of confidentiality. They can also improve employees' perceptions of
Now, let me let you understand what the meaning of ombudsman. Ombudsman means like a third party who is not in the hierarchy of the organization, is not working for the organization. He might be outsider, or he might be out the chain of command. Means because we won't see isolate him from his power. Not because he's sitting on a chair that he would say, "Hey, I'm the boss here. You listen and you listen and you listen." So we are trying to avoid this by bringing someone who got no any power of authority within the organization. And this guy will start to solve the problem with the people who are parties or who share the problem together, who are having uh, benefits of resolving and getting a resolution for the problem of the conflict or whatever the problem is. So he would sit with them, but not with the power of authority. Again, it's out of ombudsman is out of the power of authority for solving any resolution, for solving any problem, and getting a resolution for any problem between employees or between the employees and the employer, okay, or between several levels in the management. That's the same thing will apply.
justice. Mediation is a tool for developing appropriate and fair outcomes for all parties involved. Mediators use either a facilitative or evaluative approach to dispute resolution. Facilitative techniques foster communication among the parties and help uncover options for settling. Evaluative techniques, on the other hand, point out the potential weaknesses in each side's cases and offer potential settlement options.
So one of the main reasons for using the mediation or yeah, the mediation, sorry, One of the reasons for using the mediation is we try to find out the weak points for each party to avoid it. We're just settling now to come to a solve that will be a good and satisfying all the parties of the conflict or all the parties of the problem. Okay, we want to come to the middle of the way. We want to find some things. Of course, any kind of disputes, to find the resolution there must be kinds of sacrifice. I have to sacrifice and you have to sacrifice so that we will come to a meeting point. We will come together to a meeting point, to a point that we will agree on. So this kind of mediation is just trying to see what are the weak points for each party and trying to work on it, avoid it, correct it, deal with it in a new way that will all the parties will be satisfied, and so on.
Many mediators use a combination of approaches depending on the circumstances of the dispute. Balancing both employers' and employees' rights is a growing human resource management concern because of increased litigation and the expanding global workforce.
So what I want to reach to is a balance between the employer rights and the employee rights. Okay, if I tell you in the quiz there is no need to balance between the employer and the employee's rights, what do you think? There is no need to balance between the employer's right and the employee's rights. The employer is the boss or the manager. The employee are the workers. What do you think the answer should be? Hmm? Of course, no, because I have to make a balance between both of them. I have to create a balance between the employer and the employee as well. Yeah.
Employers have legitimate rights to ensure that employees are doing their jobs and working in a secure environment, while employees expect their rights, both on and off the job, to be protected. Managing employee rights requires workplace investigations to occasionally be conducted by internal or external personnel. A workplace investigation is not an effort to prove or disprove allegations or to determine whether allegations are true. A workplace investigation is designed to find the facts and to determine what happened or what is happening in a situation. An investigator for the organization has the responsibility to look beyond the simple incident or accusation to examine the situation as a whole.
This is also another way to solve any problems or any conflict or any dispute between the workers who are the employees and the managements and the managers who are the employer. It's like the workplace investigation, which look on the ground for what's going on and checking out for the facts and looking for who made the mistake just to avoid doing it again and not to blame one party or whatever or take correction steps. So this is what's happening in this situation because I have to like to check out on real
Human resource
situation.
policy serves as guidelines and standards on the approach the organization intends to adopt in managing its people. Human resource policies state the intent of the organization and represent specific guidelines on various matters concerning employment. A good HR policy provides generalized guidance on the approach adopted by the organization and therefore its employees concerning various aspects of employment. Policies serve as a reference point when decisions are being made about an organization's workforce. Human resource policy serves a variety of critical purposes in an organization. Human resource policies provide a basis for treating all employees fairly and equitably, clear communication between the organization and their employees regarding employment, and a set of guidelines for supervisors and managers.
You see now,
The
this is
previous sections of this course, we talked about employee rights and organizational rules, providing the backdrop for a discussion of employee discipline based on those rights as a key issue in disciplinary cases. Discipline is a process of corrective action used to enforce organizational rules.
so I want to apply the discipline or discipline. I want to apply it so that there will no breach for the employee's rights or for the employer's rights. That's why I'm doing this.
Key to managing employee rights is progressive discipline, which incorporates steps that become progressively more severe and is designed to change an employee's inappropriate behavior. Most progressive
So the discipline is helping to each one. I know what I have to do, and you as an employee, and you know what you have to do as an employer. So everyone know his limits, and everyone know what is he has to do and what he has not to do in the job. Okay, so each party is having his own duties, responsibilities, everything. Who will care about all this? The discipline. Okay, yeah.
discipline procedures use verbal and written reprimands, as well as suspension, before resorting to termination. The employment relationship is a reciprocal one in which both employers and employees have statutory and contractual rights as well as responsibilities. The employer has a unique obligation to manage employee rights in balance with organizational needs.
Thank you so much for watching this video. Now we'll go back to our slides. We'll go back to our slides. So after watching the video, what do you think? Do you think that the rights of employer only, or the rights are the rights of employer and employee, or is it the rights of employer and employee together? The third one is the answer. Okay, we saw many ways for resolving and for getting all the problems and the conflicts out between the managers or the management and the employee or the workers. Which one of them you prefer? If you were a human resource manager, which one would you prefer and why? Give me a reason why. Those are the expectancy rights, which we talk about: substance abuse and drug testing, employee privacy, access to employees' files. This is I know that all my work is secrets, and no one will come unless is having a permission to do this. Electronic privacies. My email is not. No one is hacking my email or whatever. Employees conduct outside of the workplace. How they are working together out of the workplace. Like we have always there is a formal organization and there is it's called informal organization. Informal like a friendship, and this is we may be in the morning working together, informal in the formal organization, but in the afternoon we go outside, we play billiards together, we play football together. This is called informal organization. Disciplinary policies and procedures, effective policies and guidelines we have to use. Like we said before, there must be a guidelines, because everything when it's written and shown up and even verbal, everything is shown up, then everything is clear, then the dispute will be to the lowest levels. Then justifiable reasons from justice, like, or from justifying. Yeah, key responsibilities for discipline rests with employees' immediate manager. That's fine. Setting organizational expectations, we said before, this continues. Clearly stated expectations are the foundation, because when it's clear, everything is fine. Expectations govern employees' behavior standards. Yes, I said this before. I said the expectations, your expectations about the organization which you are working in, which you are okay, will say what kind of behavior you will do. Important to communicate to everyone in the organization. Communication will solve a lot of problems, like we said before. Expectations govern employees' behavior standards. This sentence we said before. I want you to comment on it and give an example of your own. We talk about the discipline in the video, so all this is repeated words now again. But anyhow, Discipline treatment that punishes. Orderly behavior is an organizational setting or training the modules and strengthen describe conducts or correct undesirable conduct and develop self-control. Like we said before, it's rules. What I'm doing in these rules is just trying to minimize the conflict, okay, and the disputes to the lowest level. Common disciplinary problems, attendance issues, untruthful, I'm telling lies, performance at work, I'm doing my job without morale, or I'm doing less than the standard. My outcomes are less than the standard. Okay. Behavior issues like using alcohol or drugs, non-compliance with when given a direction. So as a manager, I tell you do this, you don't do it. You go and you refuse to say to do what I asked you to do. Those are all behavioral issues. So investigating the disciplinary problems, we have to make a documentation first. We have to make an interview for investigation, like check out what's happening, what's going on. We have to see why did you refuse to obey the orders or the instructions of your employer. He told you to do this, but you didn't do it. Why? Approaches to disciplinary action: progressive, corrective, or punitive. So there will be always the carrot and the stick. So for the carrot, there is a reward. For the stick, there must be punishment. Otherwise, you will do it back. Increasing corrective. So, but the reason for this all is to correct all the mistakes and not to do it again. Positive discipline, joint responsibility, educate and involve in the work of in this process. Compelling a disciplinary record, complete written record about the problem retained in employees officials employment file. You will keep it in its file. So if you make an investigation and you found that this he was condemned, the employee was condemned, then in this case you will put it in his own file and use it further, or at least it will be like a red mark in his own file that he had been punished before or whatever. He made a mistake, he breaches the laws of the company. Can assist an employer in identifying work expectations that are counterproductive. Counterproductive means against production to organizational success, means what he's doing is against the company's success. He's not working, he's not producing, he's this all against the company's success. Grounds for termination. What are the reasons will make me terminate? Means end the contract of some person. What are the reasons which will make me end the contract of some person? Let's see. Uh, just cause, clear and consistent performance expectations, series of incidents, uh, employment given time, opportunity, resources to improve himself, but he didn't improve himself. This is a ground for termination because he didn't improve. I gave him a chance, one chance, and two chances, and still he's making the same mistakes. So why I will keep him on working in the company because I want to make lose to lose? No, no. Then in that case, I will get rid of him by terminating him. Investigation and warning to employees, appropriate consequences, and proof. There must be a proof for a termination. There must be a proof for termination. I won't terminate anyone without any proof. Okay. I will show him like first, hey, you made a mistake. You shouldn't repeat this mistake back. Watch out. Take care of this point and blah 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 blah. Then I will watch him. He will do it back or no. It will be set in his records. Then after this, when it's repeated, and he had a knowledge before about the problems which he did, and he's still insisting to do it, that means he do it purposely. So in that case, this is a good a reasonable ground for terminating this kind of employees. Grounds for termination: also wrongful dismissal, permitting an employee's employment without just cause, uh, this wrongful dismissal, actually it's happening some places and some companies just dismiss this employee without giving him reason why. And in most of the cases, he didn't make mistakes. Why? Constructive dismissal, changing an employee's working conditions such that compensation status or prestige is reduced. So, constructive dismissal means that you are taking $3,000 salary and you are working 45 hours per week. I will make them 20 hours per week and I will give you 1500 only. Okay? Working conditions change it, such as compensation, status, or prestige is reduced. Look at this, is reduced. This is called constructive dismissal. When I reduce your job, when you've been raised, then I will tell you no. I will let you, like as example, you were a general manager, and I will tell you no, 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 no. You will be a vice manager only after you are a general manager. This is kind of constructive dismissal because you put me down. Terminating employees, still we are in stressful for both manager and employees. Termination meeting. When I meet you now, when I say to you, sorry, I don't want you to work with me, it's of course stressful for both of us because it might go up to be escalated, like well planned out. It must be planned. Ensure that the employee's legal rights are not violated. Make sure that when he's going, he took all his rights. Okay, because if he didn't take his rights, this will be a reason for serious problems with out parties. Like as example, you might go and complain in the union or in the Ministry of Labor or whatever. So make sure when you terminate that this employee has all the package of his rights before he leave. Employee's departure from the work location and confidentially from the work. Okay, and it must take a figure of confidential, like confidential. It's not like a matter of hey, okay, bye bye, see you later, take care, wherever you go. No, it must be documented and must be known what time and what exactly and this and that, and everything must be in the records. Terminating employees continues providing career transition assistance results in of inaction. Questions. Please watch the following video regarding the employee's termination. Take notes and we will be prepared to answer the following questions. The following questions which we will answer after watching the video are: what do we mean by termination? What are the reasons of employee termination? What are the reasons for the termination? We said this before. Discuss the employee's termination steps in Canadian business organization as example. So take an example of the Canadian business organization and work on it for determination, how determination will be. Actually, let us go and see the video first about the termination process. Then we will see.
Welcome, everyone. This is Amir Mushtaq from U Council. If you want to understand only one thing in Canadian employment law, then it is the concept of reasonable notice of termination. Um, it is the single most important concept that has strong bearing on your employment relationship, whether you are an employee or an employer. So we'll talk about what this reasonable notice is and what does it mean to you, and we'll explain it in simple terms so you can apply it in your own circumstances. Before we begin, we'll start with our usual disclaimer that this course is not legal advice. So if you have any specific questions, you must contact a lawyer or a paralegal. Why is reasonable notice important? Well, basically, reasonable notice is important because it may translate into significant amount of money. If you're an employer, you may end up providing a significant amount of money to your departed employee. And if you're an employee, you may be entitled to a large amount of money. So the relevance of reasonable notice is directly related to the money that you may get on termination.
two things you must keep in mind. So, with respect to reasonable notice, if you are terminated without cause and you are entitled to common law rights on termination, in that situation, in those when those two once those two conditions are fulfilled, then you are entitled to common law reasonable notice of termination. And just to give you a perspective, this reasonable notice could be as high as 24 months of income. So if you make $100,000 income annually, then sometimes if you meet the criteria, you may be entitled to up to 2 years of your pay. So that's a significant amount of money on termination when you're actually losing your job. So what is this reasonable notice? The main thing you want to understand is that the term reasonable notice, it's called reasonable notice commonly, but the proper term is common law reasonable notice of termination. And so what is this? It is a notice that an employer provides to an employee and basically tells the employee that his or her employment is going to end. And so this common law
So the
notice or
notice now,
termination.
I want you to tell you that the notice, I'm telling him that your contract is going to be end. I won't leave you and just stab you from your back. No, I will tell you so that you might have a chance to look for work in other places, start to apply, whatever. Yeah.
Termination notice could be given in one of three ways. So, option number one is working notice. Employer can come to you and say, "Hey, Mary, hey, John, your employment is going to end, is going to terminate as of December 31st of this year." So, let's say 12 months from now. And I am giving you this working notice. You are required to come to work every single day as if you are an employee, perform your duties. We will provide you your salary. And when December 31st comes, that's your last day. And then you go home and never come back. And then you don't get any more money. This is it. So it's a working notice. You worked the entire 12 months or whatever the duration of the reasonable notice is. And then you go home and that's the end of it. So there's no money at the end of it. Or the employer may say, "Hey, John, hey, Mary, your employment is ending today. So return your keys, return your access cards, and then at the end of the day, you go home or you leave now and you do not come back. And here is the money for 12 months of your pay." Or they may say, we'll continue to give you salary for 12 months until you find another job or something like that. So, but the determination happens immediately, and then you get the money for the notice period. So that's option number two, which is actually the most common option. Most employers do not like to retain an employee on their premises who knows that his or her employment is going to end sometime in the future, because it makes it difficult for that employee to continue working knowing that he or she is going to lose his or her job in some time in the future, and there's a date that has been announced to that person. And also it may jeopardize the relationship, it may poison the work environment. So majority of employers do not like to give working notice. Sometimes it works better and employers do that, but mostly the employers do not give working notice, that they would rather give you money in lieu of working notice. Or option number three is a combination of both. So the employer can give part of working notice and part of money in lieu of notice. So employer may say, it happens sometimes when the factory is closing, the plant is closing down in 3 months time, and your reasonable notice requirement is, let's say, 12 months. The employer may say, we expect you to work for the 3 months. So 3 months is the working notice, and the remaining 9 months will give you the money. So it could be working notice, it could be money in lieu of working notice, or money in lieu of notice, or it could be a combination of working notice or money. So that's what a reasonable notice is. It is an information, it is a notice that is provided by the employer to the employee, providing that employee a specific date, which will be the final date of employment of that employee. So notice of termination. So we talked about common law rights. So you are entitled to reasonable notice if you are entitled to common law rights. And we're talking about common law reasonable notice. We're not talking about the statutory termination notice, which is a completely different thing. So what important part you want to understand is that you get common law rights by default. Common law rights are presumed. What do I mean by that? If you get hired with a company, And let's say you don't have any written job offer, written employment contract whatsoever. Somebody interviews you and says, "Welcome, we're going to pay you X amount of dollars, and this will be your position, and can you start on such and such day?" And you answer yes, and so that is an employment contract, even though it's verbal, but you have entered into it. And when you have entered that employment contract, then you by default have all the common law rights. And that means if you are terminated in the specific circumstances of this course, if you are terminated, then you are by default entitled to common law reasonable notice of termination. But the second thing you want to keep in mind is that common law right, or the reasonable notice of termination, that presumption is rebuttable. What that means is that presumption can be displaced by a contract. So if you have a written employment contract, the employer can put in a clause which can change your common law right on termination. So it can take that away. So it can remove that reasonable notice by contract. And so how it's done, we're going to talk about that in the next slide. So displacing common law reasonable notice. One way to do that is the contract may say your employment.
Uh, I will stop the video now for reasons that it's all about the termination, and at the same time, I want you to watch it till the end after I finish my class, this lecture. So that's fine. We are good. We'll complete now the others, like what do you mean by employment termination, the reasons for get out from the video these questions, and for the Canadian business, and of course the video is handling the Canadian business as example. So take notes from this. It will help you to understand well about the topic or the idea. Appealing disciplinary actions, alternative dispute resolution, we talked about it before. The negotiations will make the problem, like will reduce the size on the volume of the conflict between the contradicted parties to the lowest limit. Mediation, we said also all this in the video which we show the arbitration, umbrellas, and the mediation and the negotiations. We said we saw all this before. How to resolve a conflict between two parties, like the employee and the employer. And we said the employee are the workers while the employer is the boss. At the end of this lecture, what came to your brain to know today more? Things which you didn't know before, and now you came to know it. Just write it down. I hopefully without opening the notes, but when you feel like you cannot memorize, just open the notes back and watch the videos again, so you will have a final conclusion about the whole chapter, what it was about. Termination and the disputes, and we talk about all the points regarding this, employees' expectations. So you write all this down, and this is for yourself. You don't send it to me. No need to send it to me. This is for yourself, to train yourself for the quizzes and the assignments and the final exam. And I will say that all will be easy. Don't worry. Nothing will come to you hidden or indirect. Everything will be clear. So don't worry, guys. I wish you a very good night, and I wish you a good stay, and stay safe as much as you can. Thank you so much, and have a good night. Bye bye.